right. Good morning, everybody. I think we've reached critical mass as more people filter in. They're they will catch up. We're just going to have a little bit of time to go through our agenda and some introduction. So substantive information will come in a bit. Plus, we're recording this. So as I've mentioned the past few times, if you are if you want to have your camera off, by all means, have your camera off. I do hope that this is a conversational training. I'm going to be going over topics, but like many of you have cases, many of you are in the midst of cases. And so if you are doing something and in your case and we're going over that topic, please feel free to jump in, ask a question. For me to talk for an hour and change would probably be boring for all of you. So please jump in. I want to have a conversation. And so feel free to chime in whenever, be it through the chat or actually just unmute yourself, which I think you all have the ability to do. But my name is Mike Jones. I'm supervising attorney here at Philadelphia VIP. I've been doing home ownership work for VIP for the past 8 years. And I'm grateful to be working with all of you volunteers and the many volunteers who have been assisting our clients in the multitude of ways, but you all in getting our clients title to their home. So thank you for coming. Thank you for all of your help. Thank you for volunteering. Today's training is going to be on Tangled title. We're going to do it's a little bit of a practical step-by-step guide on how to resolving a tangled title for the vast majority of our clients, which is through the probate process. But a lot of this information is pertinent to assisting our clients with deed transfers as well, and also just helps kind of shine a light on the picture of quiet titles too. So I'll try and pepper in some information on those as well. What we're going to be talking about today, introductions, which I've already started. We're going to talk about VIP and the Tangled title landscape. We'll talk about probates and deed transfers, and then we're going to talk about some resources that VIP has to assist you and support you all in your case work, helping your clients, and any other upcoming events. As mentioned, I am Mike Jones. No more I need to say on that. I'll bring this up again, but for everybody, new volunteer open house, we will be hosting an open house at our offices here where you all are currently with me on October 22nd at 8:30 a.m. Please come, stop by, have coffee, some light snacks, meet and mingle with the VIP staff and other volunteers. Our offices are located in Center City. We're at 2 Penn Center. We're on the 18th floor. This is in part for celebration of National Pro Bono Week. If you are interested in joining, you are welcome to reach out to me, for which you all have my contact information. Additionally, I think Joe just dropped the link into the chat. So please, you can RSVP at the website there, but you're also welcome to email me. Joe is about to go on vacation for a little bit of time, so don't email him. He'll be off enjoying siestas at any moment. So email me for the time being. Anywho, please join for our open house. We will have a great time. I love meeting our volunteers in person because so often we just do interactions over email or Zoom. So it's nice to see someone in IRL. Philadelphia VIP. Our mission. VIP leverages the powerful resources of the community to provide quality volunteer legal services and ensure access to justice for low-income Philadelphians. What does that mean? That means that in 1981, when legal services funding was cut at a federal level, we had to, our attorneys in the city of Philadelphia said we had to do something to make sure that people who were in need of legal assistance could get it. And so through the Bar Association, they created Philadelphia VIP, which relies entirely on volunteers to do our work. So we have volunteer attorneys, volunteer paralegals, volunteer notaries, volunteer interpreters and translators. We recruit and train and support all of these volunteers to help in any way possible to assist our clients with the legal needs. We have a wide range of legal needs for our clients. I think they say from adoption to zoning is what we have, but we have several different pillars. And we work as I said, primarily in home ownership. And so we can't do this work without you all. So again, extremely grateful. Why does Philadelphia VIP matter? Up until recently, Philadelphia was the highest poverty, the city with the big city with the highest rate of poverty. In about a month ago, it was announced that Houston gets that distinction. We are now the second highest rate of poverty in among the most populous cities, where our poverty rate has dropped just below 20% for the first time since the 1970s. But that is still not a distinction that we should be happy about. What that means is that there are a lot of people who can't afford an attorney, and so that they have to rely on legal aid to get the attorney that they need. And while there are a number of legal aid organizations across the city and community legal services, Philadelphia Legal Assistance, Senior Law Center, we have, and so many more, that's only capacity for so many individuals. We need to help more people. And to do that, we use volunteers to help close that gap. And one of the ways, the areas that we do this is through assisting our clients with Tangled title issues. And we'll get into what Tangled title is. Many of you, if not all of you, already know what it is, but helping our clients get title to their home so that they're able to obtain the benefits and exercise the rights as a homeowner is one of the most important ways of building and developing intergenerational wealth and allowing our clients to be the people who they want to be, have their families live in a safe and secure, habitable home, and to be able to pass down that home for generations and not lose it to foreclosure or condemnation or anything else, to even fraud. Our clients are they're living in family homes for the most part. They are taking this home because their grandmother owned it and their grandmother passed away without a will, and they've been living there for a long time. And clients like Nefertiti, who has grown up in this neighborhood, and they want to take care of their home and ensure that their children and their children's children have a roof over their head. This is truly meaningful stuff, and I am extremely grateful for everyone who's helps with us. This map here shows the issues, the range of issues that we face in Philadelphia regarding Tangled titles. Those dark blue areas in the north, the northwest, the southwest, and the west of Philadelphia. Those dark blue areas are where the Tangled titles are at the highest numbers. This is from a Pew Charitable Trust report that came out in 2021. It said that just over 10,000 properties, or roughly 2% of all residential properties in Philadelphia, are affected by Tangled title. That's a low number. That only includes properties where there's a based on their methodology, it only includes properties where there is a person who is concluded to have been dead for, I think it's at least 15 or 20 years. But these areas, the median household income is in these dark blue areas, the areas that are most impacted by Tangled title. The median household income is $28,000, well below the median of $45,000 for a household income. The poverty rate is upwards of 34% compared to the city's 20%. And the property values of these areas are about $40 per square foot, which is significantly lower compared to all of the other properties. This Tangled title on one Tangled title property on the block impacts the value of the entire block, and it can lead to a potential blighted property, and lead to lower value and can lead to people leaving the neighborhood. So it's kind of amazing thing what happens when one person gets one house, one family gets their Tangled title resolved, how it can shift an entire neighborhood. The number of times that we've had people come through our door seeking assistance, saying that someone on their block received assistance through getting their Tangled title resolved and they want to change it. It's it's viral in terms of people wanting um, to get their houses in order. So it's integral for you all to be here. So thank you. Um, okay. What is a tangled title? A tangled title is, as I've mentioned or alluded to, someone is living in their home that they are not on the deed for, but for any number of reasons, they are they should be on title. Um, that means that we at Philadelphia VIP have three different forms of tangled title cases where you can represent a client who is affected by a tangled title. The most common way that someone can be impacted by tangled title, and this is primarily the way that the Pew Charitable Trust report their methodology, was through probate or heirs property, where a family member owned the property and they died with or without a will, more often than not, just disproportionately more often than not, without a will. And maybe a generation has passed, maybe it's multiple generations, and we need to get all family members on board to get the property, to get the estate of the decedent properly opened and have the property properly transferred to our client as best as possible, and as complete as possible. Deed transfers are another way that we assist in Philadelphia VIP with tangled titles. A deed transfer is the simple instrument of having the deed confirm or convey title to the client. It's possible that the client has already gone through the probate process themselves and they've come to us, but it's also possible that they are already on title with someone through joint tenants with right of survivorship, and that co-tenant has passed away, or they're on title with their loved spouse who as tenants by the entirety and they passed away. Or it's also possible that they have a deed that is incorrect, and so they need to change the deed from Jake Moans to Mike Jones. So there's any number of ways the simple deed transfer can come through Philadelphia VIP. A lot of individuals here I know have already worked on some deed transfers. They are, it's the foundational instrument to all of the cases we do for home ownership. It's also the foundational instrument for the United States economy. So it's a really helpful tool to understand, to really help our clients with. Lastly, let me take a sip of coffee. Lastly, we have real estate litigation. You'll hear us more often talk about quiet title cases. These are clients who have come to us for a number of different reasons. They likely are not living in the property as a result of a family member being the owner, but more likely because they have had some kind of relationship outside of the family member that has led them to enter the property. This includes rent-to-own agreements or lease purchase agreements or installment land contracts, as they're known in Pennsylvania, where the client has entered into an agreement with the owner of the property and said that, over 5 years, I will pay $300 each month. And at the end of those 5 years, you, seller of the property, will convey to me the title. And at the end of those 5 years, I made the payments and I come to ask for the deed. Seller is nowhere to be found or is refusing to do anything, more likely the former. So we would go through the quiet title process to rectify that. Furthermore, we also help with fraudulent conveyances. This is something that you'll probably have read in the newspaper if you read the Inquirer. This is when a property is owned by somebody. Most likely, the scenario is that grandpa owned the property, passed away. No one's opened the estate or probated the estate of Grandpa. He died in 2010, and in 2015, Grandpa rose from the dead, and transferred the property away from our client's family to someone who has no relationship to the family. And then that person then quickly transfers it again. That forged deed, that's a typical scenario, that forged deed is void, and we need to go through the process of the courts to cancel that deed, void it, and then restore the title to the proper person and ultimately get it named in our client. The alternative way of going through a fraudulent conveyance or having a fraudulent conveyance occur is if the scenario, the outlandish scenario I say is that I'm going around door to door and I am asking people to sign a petition, and I knock on your door and I say, hey, would you like to sign this petition to nuke the whales? And you say, yes, I would love to sign this petition to nuke the whales. And so you sign that petition, and I say, haha, joke's on you. You just signed your deed. And now you have conveyed it to me. That is fraud through misrepresentation. So that deed is not void, it's voidable. I would still have ownership, but I would have to quickly move and try and convey to a bona fide third party purchaser, someone who has no idea that the fraud occurred, and has no reason to believe that it would occur through a reasonable investigation. You, as the victim, would need to move as quickly as possible to undo that deed, which through misrepresentation was fraudulently conveyed away from you. The last scenario is through adverse possession. This is, if anybody has gone through property law, they are familiar with this term, and it is not something that happens just between the wealthy and tracts of land where their woods overlap and them fighting about which trees to chop down. It happens in Philadelphia. It happens among different properties. More often than not, it's something like someone has entered into a property. This is also known as squatters' rights, where they live there continuously, acting like they're the owner for more than 21 years. In some cases, it is 10 years. That is a new law, but 21 years is the one that we all talk about. And after 21 years, they're able to go through the court process to try and get title put in their name. The fun thing about real estate litigation or quiet titles is that this is there are a lot of amorphous ways to try and help our clients. So if in a rent to own agreement, we're going through the procedure of trying to figure out who is the owner of the property, and we learn that the person who conveyed ownership from themselves and was like, hey, here's this rent to own agreement, give me $500 a month for 5 years. And we learned that person who sold it wasn't actually the owner of the property. It's possible that we can then pivot and say, well, let's go for an adverse possession claim. So there's a lot of different ways to eat Arises, as it were. And so it's a lot of fun. Real estate litigation is a fact-based investigation. It's really enjoyable. If you're interested in any of these cases, we don't see too many of them, but we are always happy to assist someone in going through these processes. What I'm going to talk about, though, throughout this training is probate, because probate is the vast majority of the clients that we assist have gone through the probate process. Even in real estate litigation, there are times that probate is necessary. If you're undoing a fraudulent conveyance that Grandpa had previously owned the property and rose from the dead and transferred the property like Lazarus, you still need to properly have standing, and to do so, to sue. And to do so, you would need to open up Grandpa's estate. So probate is part of this. So it's something that's integral to a lot of the facets of resolving homeownership issues in our cases. But before we kind of jump into the process, which I'm hoping is a little bit more of a how-to, like a practical steps, are there any questions? Anything that people want to discuss? Okay. Hearing none, feel free to jump in at any time and ask a question. There's going to be a lot of information. We have lots of resources available to support that go into a little bit more of the nitty-gritty of this stuff. But if you have a question on a case that you're working with, like, here is a time to discuss it. And I assure you, if you're working on any of these kinds of cases, and there's someone else in this room who's also working on one of these cases or they've encountered the same issue or have the same problem or will have the same problem and will need to know that answer. So chime in whenever. Okay, so probate. The way probate works in our office, as I've mentioned, is the typical scenario is grandma or grandpa owned the property. They died without a will, and our client is a grandchild. It's likely that grandma had 3 children, and our client's mother was one of the children, and they passed away. And so we have to get 2 aunts to sign renunciations. And don't worry, we're going to go over this. I'm not going to breeze through this kind of like family tree and not use the vocabulary. I'll reuse it. Don't worry, and you'll understand what it means. We'll need to get the 2 surviving children of grandma to sign renunciations and transfer, and excuse me, and then any other siblings of our deceased mother to sign renunciations, which allows our client to serve as the administrator of the estate and open up the estate. Renunciations do not convey any legal interest in the property. They just say, I nominate this individual to serve as the administrator of the estate. Once the estate is open, we can go through the administration process, which there's a few documents that need to be completed, but the goal is to convey the property. And so we would have all of those same heirs, the 2 surviving aunts and any siblings of the client, sign a deed that would then get recorded. And then after that's completed, we would close the estate and the case. So those are kind of the big pictures. So probate timeline. We will open the estate. Typically what happens is, this happens within 1 to 2 months. We'll refer a case to you. You'll review the case file and speak with the client. You'll have to determine if the estate requires a DHS estate recovery claim. You'll need to complete the Tangled Title Fund disbursement request for probate filing fee and submit the petition for probate. I'll go over each of these in a moment. Just telling you what I'm going to tell you, I'll tell you, and then I'll tell you what I told you. Here's a case summary, so we can ignore the one that I previously said. Client seeks to have title to her deceased mother's home. Client's mother and stepfather are the record owners. Client's stepfather died in 1991, and client's mother died in 2009, leaving client and 2 siblings as heirs. Client's brother and sister are the owner's only other heirs. They're willing to give client their interest in the property. A volunteer is needed to help probate mother's estate, including transferring title and filing the inheritance tax return. This is the standard summary that you can find on our website for any of the probate clients that you would assist. Obviously, there's variables in terms of heirs, but this is pretty standard. We would have a family tree in that case file. So we would show you that client's mom died in 2009. Her prior spouse, who was stepfather, died in 1991. And its client, its brother, and its sister, who are the 3 living heirs. So those are the individuals that you'd be working with. Both siblings, Mark and Regina, would need to sign renunciations for client to successfully open up the estate. And then they would then need to sign a deed transferring their interest in the home. We would also include in the case file the last recorded deed. So you'll see here that the deed, redacted as it may be, if you can see my mouse here, it says Henry and Mary, his wife, as tenants by the entirety. That means that Henry and Mary own the property together. When Henry passed away, by operation of law, Mary became the sole owner of the property. She could have, Mary, at that time, come to Philadelphia VIP and asked for us to draft a deed of confirmation. And we would have referred her to a volunteer who would have removed Henry from the deed through a recital, which comes down here, and being the same premises which Henry and Mary owned, and whereas Henry died in 1991, and by operation of law, Mary is the sole owner of the property. However, she didn't do that, and that's okay, because what happens is we can just add that into the recital when we draft the deed ultimately. That said, just keep that in mind. Henry passed. Mary is the sole owner of the property. That's what the vesting deed says. It's also important for the future to know that the deed has the property description. This property description here is what is going to be written in the new deed that transfers title from the estate of mom, of Mary, to client. Because this exact wording needs to be included in the deed. And then down here, this yellow part is the recital portion, which is going to say how mom. So here it says how mom's grantors, so James and Cecile, got title. And in the future deed that you would be drafting, it will say how the grantors in that deed. So it would say how the estate of Mary became the people who are able to grant the title. So it would say, being as the same deed that was recorded in 1978 between Henry and Mary, and whereas Henry died in 1991, and by operation of law, Mary became the sole owner, and whereas Mary died in 2009, and whereas at the point that you will be drafting this deed, you will have opened the estate in Philadelphia County, naming client as the administrator of the estate. And whereas the heirs of the property, the heirs of the estate of Mary are client and Mark and Regina. And that kind of just tracks how it's going to say here in the grantor clause, the estate of Mary, client as personal representative, client individually, client's sister, Regina, and client's brother, Mark, all as grantors, granting to client as grantee. That may be confusing to explain, but it will become clearer in a bit. That's just going to be a deed that is in your records when we send the case file over. It does two things, as I've said. It tells you who is the current owner of the property, and it's going to be the tool that is used for drafting the deed in the future. Also in the case file is going to be the Office of Property Assessments OPA page. It's going to tell you the address of the property that the Philadelphia County Assessment Bureau has. It's going to tell you what the value of that property is, which is important when we are dealing with transfer taxes and inheritance taxes. It's especially important for the time of death and the time of recording. So, if grandma died or mom died in 2009, you'll see here it doesn't go back as far as 2009. We will try our best to get that information in advance. More often than not, the person who died will be in this time period where we're able to get their information and share their value of the property at time of death, which is helpful for the probate filing fees and the inheritance taxes. We'll also share the real estate tax information, whether or not the client is current on taxes, whether or not they're an installment or an owner-occupied payment agreement for delinquent real estate taxes. So this is an informative page. Next, we will include the death certificate, include an image of it. Our client is typically, we're having them hold on to all the original documents because we don't want to hold on to the originals. We want them to. The death certificate should say, it's going to have a lot of information on it. It's going to say who the decedent is, Mary, it's our client. It'll say whether or not they were married at the time of their passing. Here, it'll say they were widowed. That's important. If they were survived by a spouse, that could change the process that we need to go through. We may need to get that surviving spouse to sign a renunciation. But if it's also a fun fact, if our client is the surviving spouse and is going to be taking title to the property, let's say they're not on the deed as a tenant by the entirety, the surviving spouse has a priority right to serve as administrator. So they wouldn't need to get the renunciations of any of the children. They can walk into the Register of Wills with your assistance without any renunciations, because the death certificate will say marital status, married, and it'll say who their surviving spouse is. But here, Mary died widowed, which means no surviving spouse. And then we will see that the informant is, this is client's name, Antoinette. And so we can confirm that that is our client. There's plenty of times that the informant is someone who is not our client, and that is helpful information as well to figure out who are other heirs. So death certificate is a part of the case file. If there is a will, we will provide a copy of the will. Our client is going to be holding on to the original will, but we will have that will here just in case. As seen in this will, clients, in our case summary, client's mother did have a will. It did appoint our client to serve as the executor, and did give the property to client and her sister. That may not always be the case. There may not be a will, and if there is a will, it may not go in favor of our client, and it also may have other issues with it. If anybody here has worked on wills with us or with another organization, you have maybe seen a lot of ways that like wills need to be this way. We need to have it signed at the logical conclusion. There needs to be just blanked on it, but a self-verification that this is a self-proven will signed by two witnesses and notarized. This is not a self-proving will. And so, you know, to walk into the Register of Wills office, they may have some extra hurdles, however small they may be, that way we need to go through. But if there's a will in this case, we would include the document of it. If there are renunciations needed, we would have images of the renunciations. Again, our client's going to hold on to the originals. There is a fun little fact that the Register of Wills in Philadelphia is not allowing renunciations that are executed outside the office to be admitted for probate if they have been signed and notarized more than a year ago. We do our best to try and monitor those dates as we're trying to work with our clients. So just bear that in mind. It is a rule of thumb that they are operating with. These are not always just needed for intestate estates. If there is a will and the will names someone who isn't our client to serve as the administrator, it's often easier to just have our client named administrator, and maybe our client is named as alternate or as a residual beneficiary, which is the third in line to serve as administrator. We may need to get the first named administrator or any other people to sign a renunciation in favor of our client, even if there is a will. Kind of part of the documentation that gets all bundled together and handed to the registrar's office when opening the estate. And the things that are in your case file. Determining if an estate requires a DHS recovery claim. This is a lot of information to write here that's written here. In short, DHS, there's a There is federal funding that is permitted to give people who are 55 and over to receive long-term care at the end of their life for at-home or nursing-based care. If they were receiving this medical assistance, they may be subject to a state recovery, which is the way the federal governments empower the states to collect on any of the payments that were made to assist those individuals. What a state recovery is a lien against the estate of that person who received care. There are means of getting out of that. One way is obviously just paying it. But for our clients, that's not likely the case. You can qualify for a waiver. If the person, our client, was a caregiver, was residing in the home for a period of 2 years prior to the person receiving care, was receiving that care, and our client has no alternative permanent residence, they can qualify for a DHS estate recovery undue hardship waiver. In all of the process, in all of the cases, we advise that you reach out to DHS and ask for a statement of claim before you open the estate so that you can know what you're working with in advance. We asked our clients if the person who had passed away had received care. Most of the time, they're able to answer outright. They know that they were receiving care, or they know that they weren't. That doesn't mean that if they weren't, you shouldn't check. And what happens is you reach out to DHS and you say, "Hey, there's a form letter that we have." You send it to them and you say, "Hey, I am assisting this individual with opening the estate of decedent. Did this person receive any medical assistance at the end of their life?" And DHS has 45 days to respond. Typically, they respond much faster than that. If the 45 days lapse and they never respond, then any claim that they do have has been waived. More often they do respond. And if they say, no, there was no claim, then cool, proceed. And if they say, yes, there is a claim, and it can be anywhere from, I've seen $500 to $500,000, that just means that we have to figure out if the client is going to be able to qualify for the undue hardship waiver, and we can work through that. If they do qualify, it does take a little bit of time and a process. That does not necessarily mean that you should not move forward with probate if we're pretty sure, if we're like confident in the likely scenario that it gets waived. If it's less than likely, or it's less than a slam dunk, we may say, hey, let's pump the brakes for a little bit on probate and work on this instead. I will note that if DHS does not permit the undue hardship waiver, it's possible they could allow for a postponement, which would be a lifetime deferment when the person dies. The person who, our client getting title, dies, and then they'll take this, they'll put a lien on the property and collect. DHS is not in the business of putting people out of their homes. They're just in the business of collecting liens. And so they're willing to work with our volunteers, and our clients. It's a little bit of a daunting, I can understand it can sound like it's a daunting task. But please know that we do this, we operate with DHS. We're able to support you and help our clients with this. There's also a wealth of knowledge that we have on DHS in this estate recovery guide that I drafted a few years ago. So just like know that it is going to be something that you have worked with. Excuse me, I'm trying to admit someone into this room. That I've worked on and can assist you. So before opening the estate, we want to figure out, is there a state recovery claim? Yes or no? If yes, we'll proceed with whatever due caution. You can reach out to me and we can discuss it. If no, proceed with probate. So what are the things that are needed for probate? The things that we went over: the original death certificate, or a certified copy. The will, if applicable. Renunciations, if applicable. The client will need a valid photo ID. They'll need the unsigned completed petition for probate, which we'll get into, and the probate filing fee, which we will also get into. These are the things that are needed, and we'll get into the specifics of a few of those. How do you file petition for probate? Online. And so the Register of Wills website, the link is here. If you were to Google search Philadelphia Register of Wills, and you scroll down to this area, there is an attorney online system. You can log in. This is the same login. I think it's the same login that's used for the CCP. So if any of you have a Philadelphia First Judicial District Court of Common Pleas login, it's the same information. I don't believe that you need to create a new login. If you do need to create a new login, you can apply for a username right down here. It's a very, very straightforward process. When you log in, you're going to be completing a petition for probate. And so you'll have to start a new probate, the decedent under the decedent's name. So it'll be, deceased record owner. In this case, it's Mary. And you're going to be completing information about Mary, all of which can be found on her death certificate, which is like her name, her social security, her last known address, where she died. And then also you'll be including the property, any property that's owned, the value of that property in Pennsylvania, value of property outside of Pennsylvania. Broadly speaking, this is only going to be the home. Very rarely is there any other property. And if there is other property, it is usually de minimis. So you'll be filling out what amounts to this form on that website. You'll then be filling out the names of any other heirs. If it's, if there are renunciations or will, you'll need to fill out all of this information about the names and the addresses of other heirs. Logistical step. You are going to be filling out this information on the website. This is the information that gets put onto the petition for probate and grant of letters. However, when you are submitting this document, which is the document that will ultimately need to be signed by the personal representative, our client, at the time of taking an oath of administration at the Register of Wills or virtually, that online website does not auto-populate this form. You will then need to also put in this information into a PDF as well. You'll already done it. You'll have all the information, but just letting you know, it's an extra step that needs to be done. The website for the Register of Wills does not auto-populate the information you put in onto this form. You need to do a separate form yourself to print out so the client can sign that. They will be signing that in front of the Register of Wills, either in person or virtually. So you'll need to do both, e-file and paper petition. So we have the death certificate, we have the will, we have renunciations, we have the petition for probate. We will also have to get the probate filing fee. The probate filing fee is the key to opening up the estate. For most of our clients, historically, the reason that people have been unable to do a transfer of title is the costs involved. One, an attorney costs money. The Pew report found that the average Tangled title for the median household of $88,000 in Philadelphia, the median household value, like the home value of $88,000, it will cost $9,900 to untangle a title, including attorney's fees, including probate filing fees, including inheritance taxes. So the cost is the biggest hurdle. And the Tangled Title Fund is a tool that Philadelphia VIP has, which administered excuse me, let me jump to the next slide, is a tool that Philadelphia V administers, which is funded by the city to assist our clients with the costs in Tangled Title. Our Tangled Title administrator, Jordan Bernard, is, I think, present. I'm trying to look for their name. They may have
Yeah,
disappeared.
I'm here.
Oh,
Hey.
there. Hi, Jordan. Um, Jordan is here to help with any questions you have on the TTF. But Jordan administers the Tangled Title Fund, which is a grant program funded by the city. It is designed to assist our clients with the administrative costs of Tangled Title cases. And there is a committee of individuals who are help make those decisions. Jordan, did you want to talk about potential covered costs and how to apply?
Sure. So with respect to covered costs, the TTF helps clients who are seeking to untangle their titles with administrative costs because the fund is under the assumption that clients will be receiving pro bono legal aid. So we don't cover any kind of lawyer's fees, but we cover what we call administrative costs, which are pretty much any type of costs incurred that are necessary for someone to untangle a title and receive a full title to their home. So the biggest ones are probate filing fees, transfer taxes, and the inheritance tax principal. The first two, probate and transfer taxes, are completely necessary to obtain title, whereas inheritance tax principals are less necessary because if unpaid, they'll just be placed as a lien. Additional costs covered and are water and real estate tax principals. If a property is in tax foreclosure, revenue will need at least some sort of payment towards the principal in order for title to be obtained. So we will issue payments towards that as well as advertising and publication, which will come up in adverse possession cases, as well as some other quiet title matters. And with respect to applying, wow, a fun slide. So you will send an email to tangledtitlefund@gmail.com. That is the email by which I receive all applications connected to our online portal system. Basically, you will just send me the application form or the disbursement request form as seen in this slide. And the forms can be found on our website, on Philadelphia VIP's website. I believe if you're going to be working with a case manager here at VIP, your case manager can also assist you in sending blank copies to you. I'll put the link in the chat if Mike is not already on it afterwards. But you'll send me the form, which will need to be signed by you and signed by the client at separate points. And as well as the application, you will need any kind of backup information if you're requesting costs. So if you're requesting costs to be covered, you'll need receipts or let's say probate filing fees. You'll need to just let me know whether you're also requesting renunciations or anything like that, which will up the cost of probate. For the application, your case manager will assist you in getting all the necessary documents to me. The biggest thing is that you review the title report with your client and sign attesting the fact that you did review the title report. Yeah, I'm going to put my email on the chat as well, so you can ask me questions if you have anything in particular that you would want to ask about applying to the TTF or anything. But if you are going to apply in the future, you can respond to my Tangled Title Fund at gmail.com email.
Thank you, Jordan. The Tangled Title Fund application is something that we try and complete in office for our clients in advance. We can't bat 1,000, so sometimes we won't have the application completed. The important things that are part of the application for submission include the income documentation for the client and their household. As Jordan said, the signed page 4, which includes the fact that the title report has been reviewed with the client. The title report is something that we send after a case has been referred. we'll send a title report, which include, we can discuss a title report, but it talks kind of the story of a property, about what liens and encumbrances are on the property, who is the owner of the property, um, and any other issues that may exist on the property, and also kind of the narrative of what the case is. Typically, the VIP case summary is pretty good, but any other updates that could be included as well. So that's the TTF. And again, we went over opening the estate, which includes reviewing the case file, doing a DHS estate recovery claim, completing the TTF, request for probate filing fee, which varies between like $350 and $500, and submitting the petition for probate. You'll be completing that e-file online. You'll be e-filing online. I have another guide, like I have a PowerPoint that does like the arrow thing on like the screenshots of the website in its entirety. So like if you are like, I don't know what I'm doing here, please feel free to just be like, Mike, can you send that how-to guide? It's extremely intuitive. Next step in the probate timeline, having the client appointed administrator of the estate. That is through scheduling the oath for the client to obtain letters. We have a question. Let me just finish this slide. And then sending the appropriate notice to beneficial interests of the people within the estate. We have a question that says, what if one forgets about submitting TTF application for legal advertising of grantor letters and has already submitted TTF for other expenses? Does one need to submit a separate TTF application? That's a great question. So advertising, which was included in that slide previously, we only do advertising in our quiet title cases when the court advises that we have to. So let's bifurcate this. Probate cases. We don't advise our clients go through advertising, and instead usually advise that they do what we call at-risk distribution. What advertising does is you say, hey, any unknown creditors, this estate is opened. You have a year to come forward and make your debts known to the estate. If you don't do that within a year period, you've waived your claims, and so you are barred from trying to collect on those. You have to advertise, I think it's twice. And the thing is that the TTF, it is a costly thing that takes money out of the TTF where clients could otherwise be using that money for something else. And instead, we advise that we speak to the clients, that you speak with your client about at-risk distribution, reviewing the title report, trying to determine if there are people or creditors who are trying to collect. Who are those creditors? Obviously, advertising is for unknown creditors, but getting an idea of the known creditors is also helpful. And saying like, if there is a creditor who is trying to come after you at some point, you just reach out to Philadelphia VIP for assistance with a debt collection case, and they can try and help with entering into a payment plan. We have letters to help guide you in these conversations, but the cost of advertising and probate and the time it takes is too much for our clients, when ultimately the goal is getting title. And how the legal technicality is that if you don't advertise and distribute property by transferring title, if that happens and a creditor comes after to try and collect, it means that the personal representative is personally liable for the distribution of proceeds that didn't go to the creditor. So we've appointed our client to be administrator of the estate. They've transferred title to themselves. What that means is that we're the person who is personally liable for the debt is already responsible, or the owner of the property the only property in the estate that can be collected upon. And so the, this is the worst case scenario is the client's home gets taken from them. That's not going to be what happens because like it's going to be the client learns that there's a creditor and the client then comes to VIP and we can assist with debt collection case. If there are large debts, we generally know about it well in advance. We discuss with the client about open mortgages, about credit card debt, personal debt up to $5,000. Like anything over $5,000 is something that we know about. And usually there are active creditors that are coming after the client or the estate well in advance. In my 8 years of doing this, I have not encountered a situation where advertising, where we should have said, damn, we should have advertised. So I want to put that side there. Advertising for quiet title actions. When going through service, when you have to serve an individual who is the owner of the home or the defendant ultimately, you need to serve them. Frequently, the person who is the defendant has taken the money and run or is no longer present, and we've had to go through alternative service. And alternative service, you can ask for publication, or you can ask through posting on the property, and mailing to the last known address. We advise our volunteers to request in the alternative service to do a posting and to mailing, sort of certified mail to the last known address, and to have the court push back if they do and say, no, you should do advertising. The court generally does not require advertising. They acknowledge that it's not always going to be the most useful tool for completing service. Those are the two different kinds of ways that advertising are involved in VIP's cases. Probate, we usually do at-risk distribution, and then for quiet titles, we'll have the court demand that we do advertising if it's something that's necessary in a motion for alternative service. That's a very good question. Thank you. On the second step of probate, appointing the client through having them get the oath. And I'm happy to answer any more questions on that offline. Happy to discuss it. To get the oath and then to sending the notice of beneficial interest to the required persons. The oath of administration is what the client said. It's kind of the client accepting the fiduciary duty as the administrator of the estate. It's not kind of, it is the client accepting the fiduciary duty of being the administrator of the estate. They need to take this oath. They have to have a valid photo ID. This is when all the documents get handed over to the Register of Wills, and they have that petition for probate, the thing that we here that the client's going to need to sign. That's printed out, and then the client signs right there. You can do it in person. Walk right into the Register of Wills in City Hall, room 180, with all the things together, probate filing fee, death certificate, blah, 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 yada, yada, yada. And client has their photo ID, and they're able to sign that. You are also able to do a virtual. It costs an extra $125. We are able to get ADA accessibility waiver when it's possible. But if it's not possible, the TTF is usually able to pay for that $125. But I'll say that it is usually a much easier process and less bit of a headache to just walk in. Obviously, we can't always have that if there's truly a mobility issue. So I'm not trying to push anyone in one direction or the other. Once the oath is taken and all the documents are handed over, and when virtual probate occurs, it's always preferred to still hand deliver the documents because I have had one time that all the documents got lost in the mail. It is not a happy experience. So hand delivering things is preferred to the mail. Um, it'll be a 10-day period, and then the register will send this document out with this gold sticker naming the client administrator of the estate. That will come with a packet of documentation. Part of that is going to be a notice of beneficial interest. If there is a will, it's to any of the people or entities named as an outright beneficiary, anybody who would be an intestate heir if the will didn't exist, and spouse and children who are likely to be intestate heirs. If there is no will, it would be all intestate heirs, including the spouse and children. This notice of beneficial interest simply says this person died. You may be an heir to the estate, and you may have beneficial interest in the property. We send this to everyone. We let them know that it's okay. It's technically should be completed within 3 months of the like this is when I say this should be okay. This is not like a complaint or service. This is, something that just goes with the process. Everyone is usually always cooperative and willing to do stuff. So like this is just something that we give to temper expectations in advance. We say, we're going to be sending you some stuff. You don't need to do anything there. As I was saying, this is a something that needs to be completed within 3 months. It is possible that you could time it so that the deed signing and the handing of this beneficial notice happen at the same time. So kind of don't have to mail it out. You can just hand deliver it. But once this notice has been handed to everybody, and it doesn't have to be personal service, doesn't have to be handed, it can just be mailed. There's the certification of notice, which just says that I send all of these individuals this document. So it just needs to be completed with who those individuals were, who you are, and just handed into the Register of Wills or mailed into the Register of Wills. Usually advise to do 2 copies or 3 copies so that they can have one stamped for your records. So taking the oath and then sending the notice of beneficial interest and filing the certificate of notice. That's step 2. Step 3 is conveying the property. This is the meat of all of our cases. It's the deed. Drafting the deed, you send it to VIP to review, preparing the transfer tax forms, submitting the TTF disbursement request for the inheritance taxes. It's weirdly worded, principle of transfer inheritance. It should be for transfer taxes and the principle of inheritance taxes, and submitting the deed for recording to VIP. We can record all deeds online for free or in person for free. It costs $275 otherwise, so you shouldn't have to, your organization shouldn't have to, we can do it. Drafting the deed. I kind of went over this before, but we have a deed for all seasons. If there is a scenario for a deed, we've done it, we've drafted it, we have templates, there's no need to reinvent the wheel. The big pieces are drafting this caption, and I want to remind people that something I say frequently is the Department of Records has very particular clerks. They want to make sure that this caption here, each individual listed, so personal representative acting as personal representative of the estate, that has to match this area, and then that has to match down here. So each of those kind of individuals, this has to match down here, this has to match down here, and then this has to match the grantor caption. They all need to match. If there is some discrepancy, the Department of Records has rejected the deeds before. So, and then we'll have to go back and ask the client or their family member to renew. That's why it's important to send it to VIP to review, because we have seen these, we know what to expect. Here is where the property description goes. This is, as I mentioned before, listed in the prior deed. I like to have the prior deed and maybe another previous deed or another instrument like a mortgage that has the property description, just so I can make sure that there's no anything that's incorrect in that. But if you're only working with one deed, usually that deed is perfectly fine. Property description explains the properties placement. Then this last part here is it's the recital. And as I had tried to explain before, potentially confusingly, this says how these grantors came to be the grantors. So it'll say the prior deed between Henry and Mary. Henry died, Mary died, the estate was opened, and the name of the administrator is this person, and the heirs are these people. And that's how you get the personal representative and the heirs here. So that's really how the deed is drafted. There are different warranties of deed: quit claim, special, and general. Quit claim, it's based on what you're warranting, like what the person who is conveying is able to warrant. We use special warranty deeds. I think general warranty is okay. We don't, general warranty is more than okay. General warranty is the highest warranty. It means that I can warrant everything behind me too. Special warranty means that I can only warrant what I'm giving. And then quit claim says I can't warrant anything. So like if I give someone the moon, I better be quit claiming it, because when they find out that I don't own it, they can sue me. And then, but the language is already there. The things that need to be changed in the habitum, which is the part of the conclusion, is what type of ownership. If a person is getting title individually, then it's usually fee simple. But if someone is going to be getting sharing it with a spouse, or maybe there's some kind of collaborative case where we're going to be helping our client get title through joint tenants with right of survivorship of a sibling of theirs, we might have to explain that it's joint tenants with right of survivorship here. Witnesses are not required in Pennsylvania, but it helps in any, like in the future, for support of claims of fraud, support against claims of fraud. So if you're able to include witnesses, that's great. If the individual who is getting the deed signed can't have any witnesses sign it, that's fine too. There's usually rarely claims of fraud when there's a witness who's signing the deed, but it's helpful. I could talk about deeds forever, so I'm going to skip through this, but I love to review it. If you'd like, please do send any deeds that you're working on to VIP. But if you have more particular questions, happy to discuss. Philadelphia and Pennsylvania transfer taxes. These two forms have to be recorded with all deeds, whether or not there are transfer taxes that are going to be paid. What transfer taxes are a percentage of the value of the home, or the payment for the home, the consideration for the home, paid to Philadelphia and to Pennsylvania. I don't want to get too in the weeds on this. There's a calculation for it. Usually it's it's going to be 1% of the property value to Pennsylvania, and 3.578 of the percent of the property value to Philadelphia. In total, it's 4.578% of the property value. That is what the consideration is. The alternative is that it could be, that could be what the value, fair market value, and what transfer taxes are based on. The alternative is it could be based on consideration. There's usually no consideration when we're going through our cases. There has been a recent opinion from the Pennsylvania Department of Revenue, and Philadelphia has agreed with it, where if a client or a person who is taking title is taking through an estate where it could otherwise be exempt, there is an exemption for a lot of deeds based on the relationship. Parents to lineal descendants, children to parents, among siblings, and grandparents down, lineal descendants and siblings, is an exempt transfer. It also includes a transfer from an estate to an individual or to heirs. However, this recent opinion has said that where an individual has inherited property through an estate and they are taking property subject to an open mortgage. So let's say there's a mortgage for $100,000 out on the property. That the Pennsylvania and Philadelphia agree that the transfer taxes are due on that mortgage. So we would need to have transfer taxes paid for based on that $100,000 mortgage. 1% of that, $1,000, goes to Pennsylvania. 3.578%, $3,578 would go to Philadelphia. And those need to be asked for disbursement in advance. We usually see these we are seeing these from miles away, so they shouldn't be a surprise. But just bear that in mind. In the future, there are more instances of transfer taxes requiring to be paid because there is other consideration with someone taking title subject to a mortgage. The deed is signed and executed, and transfer taxes, if required, has been dispersed from the TTF. We will record the deed for free. We can record it online. So Jordan doesn't even have to leave their desk, and instead of going to City Hall, they can do it from their seat. And if it needs to be recorded in City Hall, usually those deeds are from quiet title actions. Jordan walks over to City Hall and has a wonderful field trip that they enjoy. And so we can record these deeds for free. Please make sure that when you have ensured that the deed has been signed and notarized by the client, by anybody who's signing it, you send the scan or the original to us for recording. We can do the scans as long as it's a good scan. So you can hold, if you are holding it, you can keep holding it. Once it's recorded, we will send it back. If we have the original, we'll send it to the client if they want, or they can come pick it up. We'll also send the scan of the recorded deed your way. And if you have the original, what you do is you just staple the front page of the recorded deed to the original, and there you have it. That's the proof that it's been recorded. Again, reviewing what we just did, conveying the property, drafting the deed, preparing the transfer tax forms, submitting the request for transfer taxes and inheritance taxes, which inheritance taxes I'm going to go over, but we're going to breeze through those and leave time for questions. Inheritance taxes, they're not a monster by any stretch, but most people who enter the law don't want to talk about math. And then submit the deed for recording. The last thing, probate timeline, closing the estate. This includes filing the inheritance tax return, filing the final inventory, and then status report, which closes the estate. As I've mentioned, the inheritance taxes, it's simple math, but it's math. We have a guide for it. I love to do inheritance taxes. What I usually say when it's regular season is I love to sit and review deeds and inheritance taxes during a Phillies game. It gives me zen. I can't do that right now. It's too stressful, but don't worry, I'll still find time to find my zen because the Phillies don't bring me that. But if you are looking for assistance with inheritance taxes, please send them to us. Able to review them, able to help out in any way. We have a guide for it. I assure you, it is not as hard as it seems. It is a simple math problem of itemized assets minus itemized deductions equals X amount, and then you multiply that by a small percentage. And we have all of that information, those numbers already somewhere in our file. The inheritance taxes have been submitted. You can also request payment from the TTF to pay up to $1,750, $1,750 for the principal. If there is any excess principal, and if there are interest that is accrued, excuse me, you can request an abatement from the Department of Revenue, Pennsylvania's Department of Revenue, for any excess principal or the excess interest for the interest. TTF will not pay interest. It's a process that takes a little bit of time, but the Department of Revenue for Pennsylvania is extremely helpful and works with us very, very well and works with all of our sister organizations. So if necessary, request for waiver of inheritance tax principal and interest. Filing the inventory. This inventory is the form that tells, so when you're opening the estate with the Register of Wills, they say how much was the property valued in Pennsylvania. And you're going to say, is valued at $100,000 because that's what this property was. And there was only one home and there's only one piece of property and it was the home. Here, the inventory ultimately is going to confirm the value of the home or what other assets were in the estate. So if there were other things that you didn't know, the petition for probate is a guess, and then inventory confirms that. It is the only other document required to be submitted to the Register of Wills that has to be signed by the client, by the personal representative. So this usually can be signed at the time of the deed signing. It can also be signed another time. It doesn't have to be notarized, but they need to be the ones to sign it, just so you know. Lastly, the final status report, really easy. It's a bunch of yeses and nos, and then handed into the Register of Wills to close the estate. You go over those anytime. So what did we just talk about? Filing the inheritance tax return, filing the inventory, filing the status report, and then sending the request for abatement of inheritance tax principal and interest. And what did we just discuss overall was the probate timeline: opening the estate, administering the estate, conveying it, and ultimately closing it. So what's next is, if you already have a case, please, if you have questions, reach out to me or any staff member to help answer any questions. If you don't have a case and you're interested in taking a case, I know there are several people here who are doing a pro bono contest and so a volunteer contest. So, we've got plenty of opportunities for you to work alone or together with a teammate. It's always better to work as a team. It's more fun. Please do feel free to reach out to me if you're interested in specific kinds of cases. Alternatively, you can go to our website that Joe has just thrown in the chat for a case list. And we have more than just homeownership cases, but I'm a little partial to homeownership cases. So go reach out, figure out a case. What else do we have? We have resources out the wazoo. As I had mentioned about deeds, we have every kind of template of deed, but we also have any of those forms that I'd mentioned that the Register of Wills sends, any of those letters that have to get sent to DHS or to the Department of Revenue, or in submitting deeds to the Department of Records. We have those. Those are all on our resource library. You can go to our website. It's under volunteers, the resource library. Joe just dropped the link. So any template you need, we have it. It's in there. And if it's not in there, you just email us. We have it. What else do we have? We have support from our staff, from mentors, from interpreters, from volunteer notaries, from translators. There's no dearth of people that we rely on to help support our volunteers. We don't want you to ever be in the wilderness when you take a case. So you can always reach out to us. Our staff is here to support you. But if you ever get into something too weedy or you need your hand held a little bit more, we have mentors. And if you're working with a client who is not speaking English, we are always, like, you'll know this in advance. We're never going to give you a client with a different language than English without letting that be known in the case summary. But if you would like to have an interpreter, you can let us know. If you're interested in being an interpreter, please let us know. Always happy to have more people using their skills to support our clients. Lastly, upcoming events. We have an estate planning training on October 21st. On the 22nd, as I've already discussed, we have the new volunteer open house. Please come. And then on the 29th, we have small business CLE and legal clinic. So a few things coming up in the next few weeks. We are excited to have you here. And we're excited to work with you in the future. And that's everything. So ready to say yes, ready to take on a new case. I am extremely grateful for everyone here. There's plenty, 6 minutes left, but if you have questions, please feel free to ask them. If you are interested in taking a case, you're welcome to talk to me right now. If you're interested to check it out yourself, Joe listed the case there. I'll be here for now, so you guys, I'll stop sharing, but you all can ask questions or do whatever you'd like right now. So thank you all very much for coming. I'm extremely grateful for all of you as volunteers. I'm extremely grateful for you as an audience member. So thank you. And go Phils. Please beat the Dodgers. At least once.